straight ahead on Law&Crime Daily.
You indicated that you have a very negative impression of Kimberly Potter.
Jury selection is underway in the trial of ex-Minnesota cop Kim Potter. And witnesses take the stand in day 2 of Ghislaine Maxwell's federal trial. We bring you the latest from inside the courtroom. Plus, a New Hampshire jury hears opening statements as a man stands trial for the murder of his wife.
The defendant's anger and resentment toward Maureen intensified. Bill Argie did not murder his wife.
And later, we hear from both sides in the death of Ahmad Arbery trial.
As prosecutors, it is actually very rare for a defendant to actually take the stand.
We felt that it would be the right thing for him to step up first.
Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm Brian Buckmeyer along with Terry Austin. We begin with news out of Minnesota where the defense says former police officer Kim Potter will testify in her own defense. On charges of manslaughter in the shooting death of Dante Wright, jury selection in the case began on Tuesday. In April of this year, Brooklyn Center, Minnesota officers pulled over Wright for an expired registration tag. Officers determined he had an outstanding warrant for a weapons charge and attempted to take him into custody. Body camera footage shows Wright resisting the officers. Potter warns Wright she will tase him, but instead of a stun gun, she pulls out her gun and shoots him in the chest. Wright, a black man, was unarmed at the time. He later died. Potter's defense argues Wright's death was an accident. On Tuesday, both sides questioned potential witnesses about the highly publicized trial.
Is it fair to say that what you're telling us is it's not really personal?
No.
It's just
No.
somebody's dead.
Yeah, just the circumstances around the whole thing.
Right. And obviously, you have some sympathy for a young man who was killed.
Of course.
And an officer who made those
Yes.
actions.
Yes.
And as you sit here today, can you tell the court that you can set aside those impressions, those feelings, and decide the case based solely on the evidence presented to you in court?
Yes.
Joining us today is criminal defense attorney Adam Conta and Terry Austin. Adam, I would expect the prosecution to have a lot of police and use of force experts in this trial. Does that affect who either side will be looking for in a juror?
Yeah, of course. I mean, they're going to be looking for a few things. You're going to be looking for jurors on the prosecution side. You're going to be looking at jurors who don't have a bias with police and have a bias against this whole sort of movement that's going on, but also to be open to the idea of what experts can offer, just the very idea that there can be a qualified expert that can give opinion and have sort of a weighted insight into a case. This is going to be a very, very tricky case that so much of it is going to be done during jury selection. When there's this much that you can see in the video, it's just about interpreting that video. There's no other evidence, really. It's just a 30-second video. So this case, I really believe, can be won or lost right here, right now in voir dire.
Absolutely. It's amazing that we have the ability to record that, where in many cases we actually don't. Terry, opening statements expected on December 8th. Jury selection can be as long as it was in Brunswick, Georgia, or as short as it was in Kenosha, Wisconsin. How long do you think selections will take here in this case?
Well, at first, Brian, I thought it was moving quickly. I think it slowed down a little bit. They selected that first juror very quickly. Now they have 3, but they have plenty of time before December 8th. They have 6 more days altogether. And if they want to do the 12 jurors, I think they can do it, plus the alternates. I've got to say, I am impressed by this judge. She's deliberate, but she keeps the case on track so far. And both of the attorneys are being very reasonable. They're not perfect jurors, but they believe that these jurors will listen to the evidence, and they're trusting that that's going to happen.
Absolutely, it makes sense, and we'll obviously give you up-to-date information as we continue with jury selection in the case of Minnesota v. Kim Potter. Switching now to federal court out of Arkansas, where jury selection is underway in the trial of Josh Duggar. The former reality TV star, best known for his family show 19 Kids and Counting, is charged with possessing child pornography. Back in 2019, authorities traced child pornography downloads to Duggar's IP address. The media involving children as young as 18 months old was found on a computer at Duggar's car dealership. While the 33-year-old was arrested in April of this year, allegations of his illegal behavior date back to nearly 2 decades. In 2015, a previously sealed 2006 police report was released claiming Duggar sexually molested 5 girls as far back as 2002. 4 of the victims were his sisters. To add to the mounting case, months after the molestation reports, Duggar admitted to being unfaithful to his wife after his profile on the extramarital affair site Ashley Madison was leaked. Ahead of the trial, prosecutors asked a federal judge to allow them to use Starr's previous scandals to prove his allegedly criminal conduct. The judge ruled the decision will be under advisement. If convicted, Duggar faces up to 20 years in prison. Just months after his release from prison, prosecutors asked the United States Supreme Court to throw out the ruling that freed comedian Bill Cosby. Back in June, a judge overturned Cosby's 2018 conviction for sexual assault, saying the actor's rights had been violated. The ruling was based on a verbal immunity agreement made in 2005 that Cosby would not face charges when a woman claimed he had drugged and sexually assaulted her. But in 2015, the actor was arrested after the original investigation was dropped and a settlement was reached between the woman and Cosby. The arrest came after dozens of other women came forward accusing Cosby of sexual assault or misconduct. He served less than 3 years in prison before he was released in June. Cosby's spokesman Andrew Watt says sat down with Law and Crime's own Anjanette Levy to talk about the appeal. We'll have more from the interview on the next episode of Law and Crime Daily. Still ahead on Law and Crime Daily, a New Hampshire man on trial for the murder of his wife. But was it suicide? Hear opening statements from both sides in the trial of William Argie. But first, the federal sex trafficking trial of Ghislaine Maxwell. Our own Adam Klasfeld is live at the courthouse with the takeaways from day 2.
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTubeTV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTubeTV today and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTubeTV. We put you in the jury box.
Welcome back to Law and Crime Daily. Tuesday marks day 2 in the high-profile sex trafficking trial of Ghislaine Maxwell, the longtime companion of disgraced financier Jeffrey Epstein. 59-year-old Maxwell faces multiple sex crime charges, including sex trafficking of a minor and enticing minors to travel to engage in an illegal sex act. The charges stem from a long-time relationship with Epstein, who prosecutors say Maxwell served up girls to. In 2019, Epstein was found dead by suicide following an arrest on federal sex trafficking charges. Let's now go to the Southern District of New York courthouse where Law and Crime Network's Adam Klasfeld is live. And Adam, you've been inside the courtroom for all of Maxwell's trial so far. How did things shape up on day 2?
Well, it was very emotional testimony, Brian, today. We had today in the afternoon session the testimony of Jane, the first accuser who the prosecution introduced a jury to yesterday, saying that she was sexually abused by Jeffrey Epstein and Ghislaine Maxwell when she was 14 years old. Now, it was very emotional testimony. Her voice cracked at multiple occasions on the witness stand. She said late in the afternoon, when asked about the long-term effects of this abuse, that compared it to being a broken compass, said, how do you have healthy relationships when you're acting with a broken compass? And spoke about the devastation, the toll of it. This was one of the most sought after testimony immediately following Jeffrey Epstein's pilot speaking about her on the witness stand earlier.
Thanks, Adam. As we know, we can't go inside the courtroom. It's a federal courthouse with no cameras, so we appreciate it and thank you so much for bringing the courtroom to us in this late edition of Ghislaine Maxwell's federal court case. We'll make sure to catch up with you next time.
Thank you very much, Brian.
Yeah. Coming up on Law and Crime Daily, new insight on the Ahmad Arbery trial as we hear from the defense and the prosecution after a guilty verdict just last week. Plus, we take you inside the New Hampshire courtroom where both sides deliver opening statements in the trial of William Argie. Welcome back to Law and Crime Daily. Opening statements are given in New Hampshire, while William Bill Argie is accused of murdering his wife, Maureen. Prosecutors say the 46-year-old killed his wife by strangling or smothering her. She was 39 years old. Argie was the only beneficiary on her $400,000 life insurance policy. Prosecutors say Argie lost his job as a physician's assistant and accumulated mounting debt as a gambling addict. They say Argie asked a friend to help kill his wife, and when he declined, Argie asked for his help hiring a hitman. Authorities say Argie killed his wife, then attempted suicide after he threw away his cell phone and gambled at a casino. In opening statements on Monday, the prosecution said Argie showed no care for his wife after her murder. Prosecutors say after he tried to kill himself, Argie ran away from the crime scene, showing no consideration for his wife.
So the defendant bandaged up his injuries. He took care of himself. He showed concern for himself. But he showed no concern for Maureen. For Maureen, he left her to rot in her bed. And after he took her life, he took her car, and he took her phone, and drove away, free from the person whom he blamed for all of his problems. He fled. No calls for help. No calls to family. You will see maps from the records recovered during the investigation documenting that while Maureen lay dead at 118 West Road in Londonderry, her phone left that residence and continued connecting with cell phone towers all the way down to the Nashua area.
The defense countered the prosecution's opening statement, saying Maureen Argie committed suicide. They say Bill Argie found her with a bedsheet tied around her neck.
Maureen Argie's death was not a homicide. It was a suicide. You see, in the middle of the night, in a moment of desperation, Maureen Argie did a terrible and tragic thing. You may never know exactly why she did what she did. She left no note explaining her decision. She told no one of her plan. All we know is that on April 3rd, 2019, Maureen Argie went upstairs alone. She went to bed alone, and she killed herself alone. Maureen Argie's death was not a homicide. It was a suicide.
Let's bring back criminal defense attorney Adam Conte and co-host Terry Austin. Terry, there are no witnesses or other direct evidence in this case. Is there enough circumstantial evidence here to convict Argie?
Brian, it would be great to have an eyewitness or even a videotape of this, but there is plenty of circumstantial evidence to convict William Argie. First of all, we have that neighbor's security camera that the prosecution mentioned, where you see him going in and out of the house and no one else going in and out. We also have those matching cell phone records where he took the phone of him and his wife and took the phone and drove to go gambling. And so we have those tower records where everything is matching up. And that shows that he's trying to get away. And then we have the most important witness, who was his friend, talking about the fact that Argie wanted him to kill his wife. And then when his friend said, no, I'm not going to do that, he asked his friend to help him find someone to do it. I think all of that together is going to definitely help with the conviction. And finally, we have his daughter, who actually opened the door and saw her mother lying in the bed there. So there's enough evidence.
Adam, the defense opened kind of big in this case with saying how Argie found his wife. Does the opening statement suggest to you that Argie may actually testify in this case?
It doesn't necessarily suggest that, but I think that it's extremely likely. The only way that this story that the defense attorney opened really gets in front of the jury, other than them just sort of saying it as conjecture, is going to be from him. So he's going to need to get up there. He's going to need to emote and say how shocking and just viscerally, mentally damaging it was to walk in and find his wife this way. It was so shocking that he needed to drive and almost commit suicide himself and then gamble. I think he's going to need to get that out in front of the jury himself. So I don't know if the opening necessarily suggests it, but I think this case suggests it, if that makes sense. I think he's just going to need to say to the jury what happened, his version, in order to have any shot here at an acquittal.
Yeah, because otherwise the evidence, as been pointing out by Terry, the family members, the friend who's suggesting that he came to him to ask to kill the wife and then hire the hitman, there's got to be some sort of explanation of, hey, I was merely joking with my friend. You know how guys get around, we have a couple beers or whatever. And then, of course, as you point out, Adam, the finding of his wife's body and the acts that he does afterwards would be bizarre to anyone going out and drinking and going to a casino afterwards. But if he can get on the stand and explain that away, maybe at the very least he beats the top counts. Maybe a full acquittal, we don't know, but we'll keep up as we continue in this New Hampshire versus William Argie. When we come back, for the first time since a verdict, Law&Crime Network hears from both sides in the death of Ahmad Arbery trial. What defense attorneys and prosecutors have to say about Travis Michael's testimony on the stand. That's next. Welcome back to Law&Crime Daily. Just 1 week after a Georgia jury found 3 men guilty in the death of Ahmad Arbery, we're hearing from both the prosecution and defense about the trial itself. Last Wednesday, father and son Travis and Gregory McMichael and William Roddy Bryan were found guilty in February 2020 death of Ahmad Arbery. McMichael shot and killed Arbery as he was jogging near his Brunswick, Georgia home. McMichael and his father tailed Arbery, and Bryan recorded the incident on his cell phone. Travis McMichael was found guilty on all 9 counts. Gregory McMichael received 1 not guilty verdict, and Bryan received 3 not guilty verdicts. All 3 men face life in prison. On Tuesday, prosecutor Linda Denikowski told Law&Crime Network how her team prepared for Travis McMichael to take the stand.
When any defendant takes the stand, it is a challenge, because the biggest fear for a prosecutor is that they're going to come off as sympathetic, or that some juror is going to feel sorry for them or buy their story. Now, we had analyzed as a team his statements repeatedly, and we had actually developed a cross-examination that we rehearsed. Paul actually played Travis McMichael, and we practiced it. Now, of course, as you know, no cross-examination plan survives contact with the enemy, and we had to pivot because you never know where the defendant's going to go. You never know what he's going to agree to, what he's not going to agree to, and when he disagrees with something you've said, and you know full well that that's a lie, you've got to be able to pull up the transcript of his prior statements and question him about those things.
Travis McMichael's attorney, Jason Sheffield, also spoke with Law&Crime Network. He says his client was adamant he must tell his side of the story.
The first moment that we saw Travis there in a jail cell, right after he had been arrested and we took on his representation, he was adamant that he needed to explain himself. Fortunately, we felt the same way, because in a case such as this, where you have taken another man's life, and you've done so because you believe that you yourself were about to die, you have to explain that fear. You have to explain that thinking to the jury. And so instantly we were connected on the idea that Travis was going to testify. It was our call that he testify first, and that he do so prior to any other witness testifying on his behalf, because we did not want the jury to think or feel that he had the benefit of other witnesses testifying about him or about his experiences or about the neighborhood.
Adam, you've had this conversation as a defense attorney with a client, whether or not they should testify. It's absolutely their right, but your thoughts on Travis McMichael testifying in this case?
Yeah, I was just in Rikers Island yesterday having this conversation, and it's a very tough one. I think a lot of attorneys are scared to put their clients on, and it is sort of rare. But I'm not scared of it, and I don't think other attorneys should be either. And I think what he said is correct. It didn't work, but there's no way for a jury to really get the sense of what someone's feeling without them saying it. So in a case like this, where he's saying self-defense, and it doesn't look like self-defense, you watch that video, it's visceral. It does not look like self-defense. So if you're going to try to convince a jury of that, you got to get up there. You got to really put yourself into it. You got to really have the emotion and express the fear that you were feeling. So I think it made a lot of sense, even though, listen, it's easy to Monday morning quarterback and say, oh, it didn't work. It was a bad decision. I don't think it was. I think it was the right call. It was just a tough evidence.
Yeah, and I think to Jason Sheffield's credit as well, the order in which he wanted Travis McMichael to testify was also very important. You don't want to put him on the back burner as a witness who's heard all the other testimony from his side and then is trying to say, hey, well, you heard what everyone else said. This is what I think as well. So putting him first and foremost, especially before the other defendants, was pretty good, at least in my opinion. Terry, looking at how the prosecution prepared for this trial, does the result surprise you? And was there a part of their prep that stood out to you?
Listen, Linda Dunikowski was amazing. She was the epitome of excellent lawyering. Nothing surprised me. And it is no wonder that when she came out of that trial, she got a hero's welcome. The key to winning any case is preparation and presentation, and Dunikowski did both. She gathered every single piece of evidence, she and her team. They reviewed all of the transcripts to make sure they knew what Travis McMichael was going to say on the stand, and she surgically executed that cross-examination. So I think you could not have done better. And by the way, her closing and opening were engaging. She did exactly what she was supposed to do, and that's why they won the case.
Absolutely. Flying colors all around for the prosecution team. Thank you both. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.